if you are charged with a crime and also have a protective order taken out against you by your significant other, it's really important for you to know the interplay in the Maryland court systems between the civil and the criminal system. In almost every instance, the protective order, because it's civil, will be heard first. Generally, if it's filed after hours by the petitioner, there'll be an interim protective order. If it's filed during hours, there'll be a temporary order. What happens at these interim or temporary hearings that you're generally not made aware of, because the hearings are granted when the petitioner, files their complaint. So these hearings are held without you present, generally speaking. Now what happens is the judge hears the evidence and decides whether or not the allegations are reasonable, and will grant either the interim or the temporary order. From there, 1 week later, a final protective order hearing will be held. At that hearing, there is a hearing. The evidentiary standard is based upon the preponderance of the evidence. The other side, the petitioner, will be able to testify, present witnesses and evidence. You'll be allowed to do the same. However, when deciding whether or not you want to testify, it's really important to remember you have a criminal case that is ongoing as well. And then why it's important to remember that is because in the civil system, you are not given the same constitutional protections against self-crimination that you would be given in your criminal case. So anything that you were to testify to at the witness stand in your protective order case could then be turned and used against you in your criminal case. You're in a courtroom, things are recorded. The state's attorney's office will have no problem getting the audio and using your statement against you. Now, a judge will then make a finding, like I said, based upon a preponderance of the evidence. Now, what's really important is to know is that if a judge makes a finding in this case, a finding against you, that's called what we call a finding of fact, and they'll make a finding of abuse. That finding of abuse can have great implications on your work and on your education. So it's really important to not leave the courtroom with a finding of abuse on your record, because it can have grave implications for the rest of your life. So you really have to have an attorney who understands the interplay and the importance of getting out of this protective order hearing unscathed and without anything incriminating on the record, so you can then go forward and attack your criminal case.